Good afternoon, everyone. What a great day to be together. This is truly a Pan-African event, but not only Africa, because we are being followed by a variety of cities in Lisbon. I'll update you on that in a moment. So, welcome to the Africa Anti-Counterfeiting Agenda, and under the title, Still Growing Respect for IP in Africa. This has been a long time coming, and we are so excited to have this launch event. COVID kind of spoiled our intentions, but we've adapted, and we welcome you to the launch event prior to a conference which we'll hold live as from next year. Today, we bring different mindsets and different experts to talk to you about all these issues, but we have a lot more for you over the next 3 days, so stay tuned and stay with us. Now, intellectual property is a subject of increasing global importance. Policymakers have long recognized the need for IP rights to protect the inventions and creative works of individuals and of firms. And in an age when knowledge capital, the product of the intellect, has become increasingly important as a basis for social and economic progress, IP has acquired unprecedented importance, and all the issues relating to the generation, evaluation, protection, and exploitation of IP systems have become crucial. We need to move forward on this issue. And this is the platform where we will debate those topics. Now, I'm very honored to have in Cape Town, live in Cape Town, our first guests, and we're going to go right over to the stage to welcome the Commissioner of Companies and Intellectual Property, Commissioner Rory Voller. And I hope that he's ready to take the stage. And thank you, Commissioner. We are so honored to have you. And he is the cabinet-appointed Commissioner of the Companies and Intellectual Property Commission, CIPC of South Africa. Over to you, Commissioner, and welcome.
Thank you very much for that warm welcome. I really appreciate it, and thank you all for making the time to be here. So before I start with my opening remarks, I would just like to mention a few of our guests and to welcome them. First, Program Director, I would like to welcome His Excellency Wamkele Mene of the African Free Trade Continental Area. It is a body that has set up recently, and we're quite proud of the fact that it has been headed by a South African, but we are all African as we are, so welcome, Excellency. Mr. Souza Rosario, he's the founder and head of the African Anti-Counterfeiting Agenda. Thank you for putting all of this together with the CIPC. We're quite pleased with the collaboration and what we can achieve going forward. To the many heads of institutions, distinguished business representatives and delegates here, ladies and gentlemen present, as well as many which are logging in virtually, which has become the norm these days, as we all know. Welcome, and thank you for the time. So good afternoon, good morning, good evening from South Africa, and welcome to the Pan-African Conference on the Anti-Counterfeiting Agenda. Still growing respect for IP in Africa. What a pertinent topic, and then something that I'm sure we're going to have robust debates and discussions over the next few days. The Companies and Intellectual Property Commission, CIPC, is hosting this conference in partnership with the Africa Anti-Counterfeiting Agenda. I'm happy to report that CIPC looks forward to growing partnerships. It is part of one of our values that we have. Collaboration and partnerships is certainly what we do and also what we're proud of. And we know that this will always promote effective IP enforcement in the training and capacity building events, as well as reaching into the African continent, which we are very, very passionate about. You know that the world of IP is a global one, but we also are Pan-Africanists, so we have to look at what we can achieve as far as spreading out our collaborative efforts and partnerships on the African continent. For those who may not know, the CIPC is the Companies and Intellectual Property Regulator in South Africa with a mandate, amongst others, to register companies. We do other areas, for example, like in the business rescue practitioner field. But we are very proud of the fact that we are fully involved in regulating, registering, and maintaining our intellectual property registers in the trademarks, copyright, patents, and design areas. As a regulator, we maintain IP data and publish an electronic monthly patent journal covering all the 4 IP domains. And we regulate the governance of a disclosure of companies. And we're very proud of the fact that we're also involved in many, many education activities, such as the one that many of you have been involved in since this morning. And also the discussions we will have will obviously tether on the facts that the educational aspect is something that we always have to discuss fully, as well as come up with concrete plans in how do we grow that. We also accredit collecting societies, a very controversial area. You know, when we deal with the issue of the amendment to our copyright laws and performance protection laws, there's a lot of debate going on. But in those particular debates and in those amendments, there is the issue around how do we regulate collecting societies and protect our artists in those various fields. I would like to urge all of us gathered here today and online to regard this important event as an opportunity to foster dialogue, most importantly, and to look at ideas to support the development of a balanced and effective IP system. Not only can we look at protection, but we also have to look at the aspect of enforcement. I think I mentioned it this morning as well, so that we grow our innovative culture, as well as look at what comes out of our IP system in order for economic investment and economic growth. In South Africa, we regard the IP system as an important policy instrument for promoting innovation, technology transfer, research and development, industrial development, and, as I've stated, economic growth. The department for which I work, the Department of Trade, Industry and Competition, is having massive debates after our State of the Nation address, because the state of the economy that we find ourselves in, and more that needs to be done. And we're also having major discussions about how do we utilize the IP system in growing that. However, like many other developing nations, we remain mindful that public understanding of the benefits of IP remains a challenge, particularly as we strive to translate our country's national economic development aspirations into contract plans and to social and economic cohesion and reality. I was just having a discussion with my colleague there about the fact that on the African continent, the IP system is not utilized to its fullest. We are consumer-based continent. We are not a manufacturing or IP-utilized continents. So that's something that we need to discuss and something that we need to change in order for us to reap the benefits, such as the Singapores and the Asian tigers of this world. Indeed, as we pursue our ambitions to achieve sustainable economic development, we cannot afford to ignore the need to raise public awareness for the respect for IP rights. But once again, it goes back to the balance that we have to get right in terms of this. There's been lessons from many countries in the world to show us that strategic use of IP can assist to break out of poverty and underdevelopment. And that is something that we have to look at, not only from a South African perspective, but on the cohesiveness of the African continent in dealing with these scourges. We've had a long history of IP protection, and South Africa as a signatory to major international treaties, we seek to ensure that appropriate balances are struck in providing protection to spur innovation and ensuring that the benefits of innovation are shared in society. Ladies and gentlemen, intellectual property enhances every aspect of our lives, as we know. I've been to so many IP conferences over the years where a person pulls out a cell phone and tells you that this part is a trademark and this is a patent and this is the design, for example. So everything that we do has an intellectual property undertone to it. And therefore, we need to understand that, appreciate it, and obviously grow the learnings from that. So all aspects of it are touched, whether it's in the engineering field, medicine, arts and culture, but also infringement of IP undermines the confidence that IP rights gives to a business. And therefore, that is the reason why we have to learn from this and grow from that. It damages the economy and can have grave impacts on the health and safety of consumers. As we've seen now also in the pandemic, we do a lot of work in the Counterfeit Goods Act arena, and we've seen counterfeit medication, counterfeit vitamins, all coming through during the issue of the pandemic. That's a scourge. Not only does it deal with the degrading of the intellectual property system, but it also is a public health issue. So those are the things that we need to be quite mindful of and deal with them. At a time when the world is recovering, and hopefully we see more recovery coming through. We must do more to protect consumers. And we must encourage the innovation of individuals and businesses by ensuring that we are doing everything that we can to help them to protect their creations. That is why we are more committed to the fight against IP crime and infringement than ever before. As I said, there are a lot of those who take advantage of the system in which we find ourselves and the position in which we find ourselves. However, the question is, how do we do it? And we continue to work together to ensure that the public understand the benefits of IP, as well as the socio-economic risk associated with counterfeit goods and piracy. How do we deal with developmental dynamics of countries such as South Africa and the African continent and provide support for small entrepreneurs and protect vulnerable creative industries? Vital for us to deal with that. And therefore the IP system can be utilized as far as that is concerned. So with those few words, may I wish you all a constructive and productive conference, characterized by robust discussions. That's always the best that we can do, is the discussions that come out of it. We can look at slides and presentation, but it's the questioning, it is the discussion amongst yourselves, and it's a discussion with the presenters, which always is most valuable, and the sharing of ideas and sharing of experiences. All of this is geared to harness and strengthen cooperation between stakeholders beyond this event, as well as to galvanize public support for the IP system. Thus, I'm sure we're all keen to engage on all of these issues and other pertinent issues in this particular system. In our quest to partner, we need to look at the enhancement of the protection and respect for IP, as well as the advancement of the balanced IP enforcement system. So with those few words, I thank you, and maybe we continue to debate, maybe we continue to discuss, and maybe we continue to grow a very viable intellectual property system, not only in Africa, but also in the global arena. Thank you very much.
Thank you so much for that uplifting and dynamic introduction. We're going to alter slightly our order because of the needs of our next guest. And we are so grateful and so profoundly honored. Thank you so much, sir, for joining us. I want to welcome now online the Secretary General of the Continental Free Trade Area, His Excellency, Mr. Wamekele Mene, to say a few words and to present his thoughts to us directly from his office. So welcome, Your Excellency. Thank you for joining us.
Thank you very much for the invitation. It's a pleasure to join you. I just heard the advocate making a very, very compelling case about intellectual property rights. And my colleagues prepared a text for me to read, but I will depart from the text to take the cue from what the advocate said. I would like to make just a couple of points. The first point I would like to make is, as we negotiate the intellectual property rights regime of the African Continental Free Trade Area, first and foremost, we should ask ourselves, what type of an intellectual property rights regime are we trying to create? Do we want an intellectual property rights regime that will be in favor, more so in favor of right holders? Do we want an intellectual property rights regime or an intellectual property rights regime that will be at the service of Africa's industrial development and be at the service of Africa's imperatives for as a developing continent? And of course, many of us across the African continent are very much in an underdeveloped state, and therefore intellectual property rights becomes very, very important as a tool for development of our continent. We now, as you may be aware, we have a mandate from the African Union, heads of states and government. Our mandate is to craft and put, by the end of September, put to heads of states an intellectual property rights protocol that all countries in Africa, those who are state parties to the AFCFTA, that all of them will be able to implement. Some of the key features of what I think we should look forward to in an intellectual property rights regime of an African, the character that we have as Africa are, for example, a developmental framework. At the WTO, for many years at the WTO, the Africa Group attempted to push through reforms of the intellectual property rights that will make it easier for African countries and developing countries when they are faced with pandemics, such as what we've gone through now, that we have a flexible intellectual property rights regime that enables countries to have access to public health, to have access to all of the tools that are required to fight not only this pandemic, but other pandemics as well. I'm afraid we didn't succeed at the WTO. We didn't succeed at the WTO, not for lack of trying, but we didn't succeed at the WTO because we were blocked. And so the global intellectual property rights regime remains largely unchanged. It remains largely unchanged. It remains largely against developing countries and African countries in particular. And so I want to invite right holders. I want to invite Big Pharma. I want to invite everybody so that we can have a discussion about a framework for intellectual property rights that will be at the service of Africa's industrialization, number one. Number two, that will be, and more importantly, at the service of Africa's public health. This is a conversation that we should have with right holders. And so we have a very unique opportunity in the African continental free trade area, a very unique opportunity to craft an intellectual property rights regime that will serve our interests as the African continent. All of the things that we attempted to do at the WTO, which we were not able to do, the paragraph 6 TRIPS amendment, all of these innovations that we were thinking about as an African continent, which we attempted to introduce into the global debate and global dialogue about reforms of the intellectual property rights regime, we didn't succeed. We didn't succeed because others said, no, we don't agree with you. We want to preserve the rights of right holders. And we want to make sure that right holders have their protections for 30, 40, 50 years. And so the point I want to underscore, Madam Moderator, is that we are very much committed to reform of intellectual property rights, but in a way that balances the right holders, the rights of the right holders, as well as our communities, and as well as the imperatives of developing countries, particularly African countries. So we are in a very, very, very unique position. I heard the advocate, all of the things that he's mentioning, and we are completely aligned in thinking, in vision about how we should use intellectual property rights to be at the service of the African continent. The last point I would make is this. We now, we have entered into an arrangement as the African Continental Free Trade Area. We've entered into an agreement with Original, a Swiss company that will work with us, collaborate with us to defeat counterfeiting, to defeat illicit trading of products across the African continent. We all know of astounding numbers that over 30% of pharmaceuticals on the African continent are counterfeit. And of course, this leads to loss of life. This leads to loss of livelihoods. It's a very, very serious and dangerous problem that we are facing. So we want to work with Original to introduce digital technologies to fight illicit trading, to fight counterfeit goods, trading in counterfeit goods. We have been in this partnership now, at least for the last 6 to 9 months with Original. We want to make sure that we work with all stakeholders on the African continent to fight to make sure that we fight counterfeit, illicit trading of goods, not only, as I underscore, not only, which is important, not only from the point of view of public health, which is absolutely critical, but also from the point of view of revenue losses. When we experience this counterfeit trading in counterfeit goods, when we experience illicit trading, our governments lose revenue. Our governments lose revenue. And so we have to be very resolute in the fight against the illicit trading of goods, counterfeit products that are circulating around our continent for public health reasons. And so we should use these digital tools that are now available at our disposal for us to forge ahead and fight against this scourge. And so I want to once again thank you very much for the opportunity. We remain committed. We will work together to make sure that we have an intellectual property rights regime that services precisely the vision that you articulated, that services precisely the public health of Africans, that services Africa's industrial development capacity. It is no longer, in my view, we cannot be importing $15 billion worth, for example, $15 billion worth of pharmaceutical products. We should use our intellectual property rights regime to create a generic drug industry here on the African continent and to make sure that we service the needs of our continent. And so this intellectual property rights protocol that we're going to craft is going to go far beyond what we attempted to do at the WTO, which we could not for lack of trying, but simply because we were blocked. We now have a very, very unique opportunity to reform intellectual property rights regime. And I hope that we can work together in this partnership and position our continent for great things to come. So I want to thank you very much for inviting me. Thank you.
Excellency, thank you so much for your frank words and your straight talking presentation, which was extremely empowering and interesting. And I hope that you will not think me too forward in saying that I think that our Congress next year, which will be held live in Africa, is the perfect opportunity for us to bring the governments together and the philosophy and launch and make sure that we move forward on this ideal, and even hold a ministers' meeting prior to the Congress. So, sir, I will be, with your permission, knocking at your door very soon. Thank you, Your Excellency, for being, for your time and for joining us. Have a great day. Thank you very much. And now we're going back to the stage in Cape Town to meet Souza Rosario. Souza Rosario was the mentor, the founder, and the passionate driver behind ACA, the African Anti-Counterfeiting agenda, and he has been fighting to get this done and to get this conversation going. So I am so proud and honored to be connected to him. So welcome to the stage, live in Cape Town, Souza Rosario. And thank you for inspiring us all, Souza.
Good afternoon, ladies and gentlemen. May I take this time to acknowledge the presence of Advocate Vola from the CIPC. May I also acknowledge His Excellency Mr. Mene from the Secretary General of the Africa Free Trade Continental Area. I am not an expert in IP. I'm just an activist. Call me an enthusiast. We began the anti-counterfeiting agenda after realizing that there's quite a lot of discrepancy in the continent. The IP landscape is different. The IP landscape differs as you go from region to region, country to country. So the purpose of the AACA is basically to create a shared vision to fight IP infringement and counterfeiting, as well as the illicit trade in Africa. We want to bring together all these countries. We want to bring together all organizations that are working in the IP domain. We want to create a platform that all of us will come together, and then we can talk about IP. We can argue about IP. We can create maybe synergies so that Africa, at the end of the day, benefits. The other purpose is for us as Africans to rid the continent of all counterfeiting and IP infringement. We also are striving to create awareness, because we realize that Africa, as it is right now, the IP approach is top to bottom. Top to bottom. We may not be involving quite a lot of these SMEs. We may not be involving the consumers themselves, and yet they are the ones that suffer the most. They pay for the products and services, and if it affects, it ends up affecting them. They are the losers of the services that may be accrued from those products, having paid taxes. So we want to involve consumers as well in the fight for a clean Africa. Right. The AACA is made up of, our approach is made up of 5 pillars. One of them is governance, and I guess this is why we are all here. The other one would be IP, which if you are in business, you are aware. But IP has been changing. IP aspects have been changing as technology evolves, as globalization grows. And we noticed in Africa that there's very few talk about digital IP. And yet, quite a big chunk of Africans are using social media. We send emails, we buy computers. Everyone uses a computer. Everyone is using a smartphone. But we are not realizing that there is IP there involved. If you are sending a WhatsApp, there is IP. You are creating content, so obviously that's IP. That's digital IP. So that's another one of our pillars. The other pillar that we also want to focus on is the humanities. For a product to be counterfeited or to be infringed, it's because there is a consumer, and that consumer is a person. And these infringers target the consumers using different strategies. There are certain products that a consumer wants to be a genuine product. So you go out of his way to make sure that he's buying a proper, genuine product. He doesn't want to be deceived. So you find the consumer, the infringer will try to make that product to be as genuine as possible so that they can deceive the consumer. So that's the full deception market. There is the other market, which is the co-conspirator. It could be because of our socio-economic circumstances. It could be also cultural, that we tend to prefer products that are coming from other continents. I think it's very African that everyone supports a team from Europe and probably doesn't support a team from South Africa or from his homeland. We tend to want to follow the fashion trends that are happening elsewhere, and we forget that we also have companies here that are supposed to be producing clothes. We follow idols, people that sing or that are actors. They portray their kind of swag, we call it. and we follow that. So most of it actually comes from this aspect that we have a tendency as people that we look upon other continents, but not look at ourselves as a people. So we are not innovating in those kind of areas. We could be coming up with our own fashion brands. We could be coming up with our own content in terms of music, in movies, but we are looking in the East, we are looking in the West. So these are trends that happen because we are people. So we want to try and reverse that trend, that as Africans we must try to belong. We must try to create our own, because the Americans, the Europeans created their own and they're trying to give it to us. So the human aspect also is one area that we believe must be looked into, must be corrected, because that is what is making counterfeiting and IP infringement rife. You cannot afford to buy a product that's made in Europe. What happens then? A counterfeiter moves in, they provide a fake, and we buy it. It's happening in cosmetics, it's happening in sports gear, sports clothes, it's happening in a lot of things. So that's the purpose of the AACA. We will try by all means to push those 5 pillars through creating platforms, conferences, trainings, and partnering with people like the CIPC. Last but not least, I just want to make a statement that IP is everything. So IP is everywhere. This is not a fight for government. This is a fight for everyone, a consumer, a brand, and the government. Thank you.
Thank you very much, Sosa. Thank you very much. Now, we are going to enter into our main debating parts. We're going to have 2 sessions this afternoon. One is the big debate, which we're going to begin in a few minutes, and the other one is our next panel, which is rights over good. But before we start, let me just tell you a few things. First, if you have questions or any comments, please, if you are online, put them into the chat area so that we can bring them to the speakers or share your comments. For the live audience, you will have your own, their own solutions in Cape Town. But I need to tell you something really, really interesting. So when we set out to do this conference, we had, of course, originally planned live, then we went back to online, then we went back to live, and then in the end, we went to a mix of both because of the situation that we are all aware of. But a few people who wanted to join us live were unable to, and we wanted to make it truly, truly Pan-African. So we reached out to a few entities, and today I'm really pleased to tell you that we are being watched currently in Mozambique. The military has opened up an auditorium for its legal people and students, mostly students. So in Mozambique, we are being followed by 135 audience. In Cabo Verde is also, the government has also opened up an auditorium, and we have 97 lawyers and students and academics in the room. And then in the University of Manchester, in association with the Africans Commission, we have 613 people participating through one link being streamed into the auditorium. And then in Lisbon at the university, also in association with the Cape Verde Legal Lawyers Association and with the university itself, we have 341 people at this moment. So I'm very, very very proud, and I welcome you all. So we're not only live across Africa, but we're also live in the UK, in Manchester, and we're also live in Lisbon. So thank you all for joining us, and let's Cape Town, hello from everywhere around the world. Nice to see you all. So our next session, which I will be kind of facilitating, because it is the job of my fabulous speakers to share their knowledge with us. So our next session is going to have four panelists joining us. So in representation of Reginald Yofi Grant from GIPC, we have Adewa Abba Arthur Esquire, who is representing him. I hope you are online, because I don't have vision of everybody who is online. So
I'm here.
Oh, hi, thank
Hi.
you for joining me. Thank you. I couldn't see you, but
My
now
pleasure.
I can.
Yes.
And our second, and this is not an order, this is simply a way of introducing them. Then, of course, we have, oh, let me just change over. Sorry, I'm so busy doing things. We have Vanessa Ferguson, who is a partner of Von Seidels, and she's in person in South Africa. So we're kind of online and on stage. So that is absolutely great. So see you, Vanessa, on stage. And Vanessa is an IP attorney with specific focus on anti-counterfeiting and associated enforcement measures. And then secondly, we have Agnes Karingu, who is already, there's Agnes. I knew I had seen you. And she's currently serving as the Deputy Director, Education and Public Awareness at the Anti-Counterfeiting Authority in Kenya. Thank you for joining us, Agnes. Okay, and then we have Maureen, who was the first to join us today, Maureen Fondo. So thank you very much. And she's the head of copyright and related rights at the African Regional Intellectual Property Organization, ARIPO. And I am so proud that I have an all-girl panel. This is very, very unusual. So it makes me extremely proud to be facilitating this panel. So the following discussion is an in-depth debate on how African governments and businesses are approaching IP matters. And it's important that here we are open about action and inaction that has contributed to the proliferation of IP infringement and counterfeiting on the continent. So I hope that people will add their questions online as we move into our conversation. So I'll go round once and ask the four ladies to tell me, and perhaps I'll start with the stage live, if the ladies online don't mind. Start with the stage live and Vanessa, and talk about what is the state of these issues at the moment as you see it from your perspective.
Great, and welcome.
I can hear you. Perfect.
Can you hear me?
Yes,
okay,
perfect.
That's excellent. It's great to be part of the panel, in person and virtual, I suppose. So
yes.
Quite something. I'm not too sure who I should be looking at. So yeah, firstly, greetings from Cape Town. And what we're looking at is really an Africa problem and how we're dealing with it. From our side, and it's one of the points of approaching the subject, is how do we do it in a positive manner? Because it's very easy to look at the topic and identify what hasn't been done or what is causing the proliferation of anti-counterfeiting, counterfeiting and IP infringements. But generally, I mean, if we're looking at it from a point of view, a lot has been happening in Africa. One of the aspects that we're looking at is, number one, the tying up of the economic issues of encouraging economic flow of goods cross-border versus the consideration and difficulty of having to deal with protection and enforcement of IP rights on a country level. That is definitely one of the aspects that we have to look at overcoming. If we look at from a business side, who is protecting their rights in Africa and to what extent? Are there enough patents and trademarks being filed that'll give us the basis and right to proceed with it? and also looking from a point of view in having the government support on the enforcement measures in each specific country. So maybe I'll just start with that and we can lead off and discuss what's happening.
Great setting of the stage. Thank you very much. I'll ask for a comment as well from Agnes.
Thank you, Linda, and happy to be part of this conversation for intellectual property in Africa. From where I sit in Kenya, this is Anti-Counterfeit Authority, which is a government institution that has been established in view of the importance of intellectual property towards development and the growing of innovations. And therefore, that is why the government of Kenya found it important, one, to pass the laws that are necessary. We have quite a vibrant legal system, and to ensure that they are enforced. So this is why the Anti-Counterfeit Authority was established. So at the Anti-Counterfeit Authority, as I've said, being a government agency, our main role is to enforce the intellectual property that has been protected under the various regimes. And here in Kenya, the laws that we enforce, the IP that we enforce is protected under the Trademark Acts. And we also have the Industrial Property Act. The registrations, i.e. the protection, is undertaken by a different institution. And the Kenya government felt there was need to separate the two to ensure that enforcement is done properly, and which we do through various processes like creation of awareness. I think the Secretary General talked about that, and it's really important towards the prevention of counterfeiting and also towards curbing of the counterfeiting. Then we also have enforcement, various activities, and to feed us, we have a research arm. I think I leave it there for now. Thank you, Linda.
Okay, and then Maureen, over to you.
Thank you very much. And I'd like to appreciate the invitation that was extended to the African Regional Intellectual Property Organization, ARIPO, in Harare, Zimbabwe. And this is an intergovernmental organization, member state driven. And currently we have 21 member states. And we are working towards creating and co-creating value by fostering creativity and innovation. We have different mandates that we have been given, and the mandates are administered by 5 protocols, which we have the Harare Protocol for patents and industrial designs and utility models. We also have the Banjul Protocol for trademarks, and we have also the Solomon Protocol for the traditional knowledge, and we have the Arusha Protocol for plant varieties protection, and the recent protocol, that is the Kampala Protocol on voluntary registration of copyright and related rights. And as an organization, we do not have direct mandate in terms of enforcing intellectual property, but we do cooperate with our partners and also with our member states and observer states in terms of ensuring that intellectual property bears fruits economically, and also the returns are realized by the right holders and the countries. So we have different initiatives that we have been doing. And as it was asked earlier, whether there are enough patents that have been filed or trademarks that have been filed, I can just give an example. For example, we have for last year, 2021, despite the COVID pandemic, ARIPO, we received applications, patent applications of 833. And these are from all across, not only in Africa, but also beyond. And for trademarks, we received the trademark applications 510. And we managed to grant for patents. For 2021, we granted 568 patents. And we also granted we registered the trademarks 305, the ones which met the requirements in accordance to the protocol. So with all this, we see that there is more that can be done in Africa. We have the potential, we have the capacity, but we just need to ensure that we streamline things so that the balance for IP can be realized. Let me stop there for now.
Okay, thank you. And Adwa.
Hi, hello everyone, and thank you for inviting Ghana Investment Promotion Center. I am one of the lawyers here at the IPA, and I'm representing Mr. Yofi Grant, the CEO. Here at the Investment Promotion Agency, GIPC, what we do is to assist foreign investors in registering technology transfer agreements, which do have intellectual property components to them. We work with the Registrar General's Department, where we ensure that any trademarks, patents are registered by the foreign investor here in Ghana to be recognized, or through the Madrid Protocol. So with assistance in technology transfer agreements, that is what we do. But in Ghana as a whole, over the last 2 decades, under the Ministry of Justice, we do have a copyright office. We have several laws, which are the Patents Acts, the Copyright Acts, Industrial Designs Act, and then Protection Against Unfair Competition. So we do work with 2 major government organizations, the Ministry of Justice and then the Registrar General's Department, to protect industrial property rights of foreign investors and also to encourage local businesses to register to protect their rights.
Thank you. I'm going to say that in preparing this debate and in preparing these issues, I found a lot of people who did not want to talk about this issue, and a lot of them and I found that it was very difficult to get people to be straightforward. And what I received also from other sources, and especially the business confederations, is that Africa was not, as a whole, was not moving fast enough. And once they had moved, perhaps they were not observing, or it was very difficult to monitor and to implement these things. I'm going to go back to the stage and ask you, Vanessa, what as a lawyer who's been working in this field for ages, is there any truth in this? First, nobody wanted to talk about it, and it was very difficult and to bring people together. And secondly, that it's too slow, and even when it's implemented, when these things are implemented, there's no monitoring or enforcement. It's very difficult, etc. And this is from investors. So tell me they're wrong so that I can go back and tell them.
Well, unfortunately, part of it is true. So we are dealing in a situation, and especially looking at Africa, where we focused on issues such as poverty, unemployment.
Yes.
The difficult issue and debate is how do we actually increase the profile and importance of IP rights, and seen that in a way that it's not necessarily anti-competitive, but encouraging investment, encouraging the economic ties internationally and locally. So definitely from a point of view, are things happening? They are happening in Africa. Are they happening fast enough? No. But and I think one of the other issues is looking from a point of view that each and every country are taking their own efforts. Yes, we've got our regional systems that are at play. We've got the Madrid, where we're looking and focusing of an international registration, but that isn't necessarily available in each and every country. So it can be frustrating, and very frustrating for brand holders and all type of industries who are trying to really get into Africa. And number one, how long does it take to register a trademark? We know there are delays in a number of countries, but not all. So we don't have that right in place. the protection of well-known trademarks, it's not consistent within African countries. So you'll find yourself in a situation where business may, for example, be focusing on those specific countries of economic interest to them, but their goods will be found cross-border in other territories. We don't have that well-known protection and a base right. If we're looking at, for example, in Sudan, then how do we go about protecting those rights that are there? So definitely it's something that there has been an improvement in Africa, but a lot of it is dealt with on a country level as opposed to regional and looking at that cross-border support of neighboring territories.
Thank you. And Maureen, do you think that where you are, that we're moving fast enough? Because it does impact a great deal from the perspective of the brands that want to invest and want to move in, as well as the businesses, because we're finding that a lot of creativity is now emerging around Africa as well, and expanding depends a lot on protection of IP. So, Maureen.
Yes, thank you very much. First of all, I'd just like to make it known that most the ARIPO member states intellectual property laws, they are post-TRIPS agreement, meaning that they have incorporated the provisions on enforcement in terms, at least the minimum general provisions of enforcement within their IP laws and established institutions that can manage the IP and enforcement. So in terms of looking at how fast we are moving, we are making progress indeed, because if the legislators found it fit and they incorporated in the laws, and that is a big milestone. And from there also, we see at the regional level, for example, ARIPO, I had mentioned earlier that we do collaborate with strategic partners in terms of the enforcement initiatives. For example, with Interpol, they have the Operation AFIA, which is the Interpol Southern African Bureau, and coordinating this. And with that, you find that there are different types of IP infringements which they are dealing with in terms of curbing that scourge. So it's not that nothing is being done. And also for ARIPO, we have also gone to the children in terms of educating them about the counterfeit and the piracy effect within their communities and the societies, and they create their own videos for public awareness. So this is at least at the elementary level, and we are continuing to do that. But further to that, we have been collaborating also with WIPO, and we had this training manual for prosecutors and law enforcement agencies, which the original text came from Honorable Judge Hams, and then it was customized so as to take into consideration the jurisdictions of ARIPO, and 10 of those ARIPO member state jurisdictions, IP was looked at and it was customized. So this is a toolkit which can be used by law enforcement agencies and also within the prosecutors. Likewise, we have also cooperated with the United States Department of Justice and US Patent and Trademark Office, and we have managed even to capacitate the judicial officers. And through that meeting, the judges, we are now working on a judicial bench book, which we see that it can guide also in this particular initiative of trying to curb and the counterfeits and also the pirated products. So there are very many different initiatives. We have our flagship program, the Masters in Intellectual Property, which also we educate in terms of awareness about the counterfeit and pirated goods. That's for now. Thank you very much.
Okay. And Adora, are you moving fast enough where you are? What can you do to take things further?
I can say that we've progressed. It's not as fast as we were hoping to advance, but we're making steps towards expediting registrations. The Registrar General Department started off with automating and having submissions done online. It used to be manual, and it took about 6 months to a year to get a registration of a trademark or a patent. But with investments made in the Registrar General's Department, I can say that if an investor goes through a legal advisor, it takes as long as 3 months, which is quite short compared to a year or a year and a half that it used to be. Ghana has partnered with the Swiss Federation to launch intellectual property policies and strategies in 2016. What we're trying to do is to inform innovators, entrepreneurs, tech savvy young people what their intellectual property rights are and how to protect them. We do need to educate more. We do need to update and upskill professionals in intellectual property. And that's where we fall a little bit short, but we are making strides to improve that. And that's what we have for now.
And Agnes, from your perspective.
Thank you, Linda. From the Kenyan perspective, are we moving fast enough? I would say that we are progressing well. We have all these legal framework that is in place. And since the establishment of the Anti-Counterfeit Authority in 2010, we've had revisions of our law so that we strengthen it. The most recent being in 2018. And this was quite a vibrant kind of amendment, because originally we were not able to receive any complaints from the consumers. They would be talking out there, but we had no legal provisions. So this gave us that provision, and therefore now a consumer or a purchaser can actually just come to the Anti-Counterfeit Authority, make a complaint, and ACA, which is the acronym of the authority, is able to pick up and carry out the relevant investigations and take the complaint to as required by the law. So that tells us that the consumers are getting more and more aware of issues of intellectual property, because actually we receive quite a number of that. Then still on enforcement, this amendment again introduced what we're calling the recordation. And this is where ACA endeavors to put together a database, particularly of the imports. Let me just say that in Kenya, most of the counterfeits, we have actually found that they come from outside the country. And therefore, to curb at source, we have introduced the recordation, which is now there by law. We have released the regulations. They have been gazetted. And this will enable all the intellectual property rights owners to record with us before the importation. There is also a provision for the importers to be the ones to record. And I believe that this will take us, will give us quite a mileage towards enforcement of intellectual property. Of course, the other aspect of it is the public awareness, which we continue to undertake. We are getting into learning institutions. We're doing all that is possible for the consumer outreach. But maybe one that I can mention is the capacity building for the enforcement agencies, the officers therein, that in collaboration with some of the development partners, like recently with the CBPP of the US Embassy, we were able to train a good number of judiciary officers and also other enforcement agencies whose mandates are linked with ACA. So there is quite a bit that is happening, maybe not enough, but yes, we are getting there. Thank you. I leave it there for now.
Okay. Now we are beginning to get questions in, but before we get questions in, I want you to comment on what His Excellency said, because he talked about the absolute need, the fundamental need to craft a regime that will serve the needs of the African continent. And we know that, for example, in 2020, November 2020, the European Union created an action plan for intellectual property rights because they believe it is the only way to guarantee recovery and resilience in the right way. So connecting this to what His Excellency said, could you comment on this idea of having something that is designed by Africans for African? We'll start on stage in Cape Town.
Leading the way from the bottom of the African continent all the way through. Definitely, I mean, if we go from a point of view, I've done quite a lot of work on an international basis, working with INTA, and a question of should we be having a African Anti-Counterfeiting Act? Is there a basis on which we can drive it throughout the continent? Definitely, I mean, if we're looking at competition, when we're looking at our local brands, there cannot be a scenario where IP rights are not protected and at the forefront. It needs to be driven from the top and downwards, and work from a basis of having the laws in place, and also from an enforcement perspective. How we drive it, how we go through it, the landscape is changing. We've seen how COVID is playing its own part, driving businesses underground and also online. And how do we actually stand together as a continent in dealing with the online anti-counterfeiting efforts? So it has to be a strong continent-driven approach that is focused on building it.
Excellent. Maureen, over to you.
Thank you very much. And we indeed appreciate His Excellency's comments that he made, the remarks. And we need to have one voice on IP issues. We have to build this one voice in Africa. And also we need to look at what is best for us in the norm setting process. What do we really need to put in place? We can take advantage, for example, the already existing ARIPO protocols as building blocks in terms of this particular work, but also we can take the legal frameworks of other countries within Africa and beyond to see what is best that can add value in what we want as Africa, our own story, the Africa that we want. So we truly concur in terms of we need that one voice in terms of building the synergies, and we cooperate together to put what we really want to ensure that Africa, industrialization, the rights holders, the consumers, and everyone involved in the IP ecosystem benefits to have a balanced intellectual property system. Thank you very much.
Okay, and what about Agnes? Your position on this?
Yeah, thank you, Linda. I honestly also would want to just echo what His Excellency said. There is need to look at IP in the African context. And let me just mention that from the Kenyan scenario, you find that we have very, very many small and medium enterprises, the SMEs, the MSMEs who are coming up, and inculcating the issues of IP among these becomes a little bit of a challenge. We are yet to get IP respect at that high level among these players, supply chain players. And therefore, sometimes getting them to understand about the issues of enforcement and why the IP is such a great issue amidst the poverty and many other priorities, it becomes an issue. And therefore, it is very important that we get to look at our context. What are our main challenges? What are our main priorities? How then do we drive IP amongst all these? And for Kenya, I want to believe that this is a debate that we would be happy to continue being in. Thank you.
Yes, I think that there is a lot of room to continue debating on how to help, especially the micro enterprises and the small companies. It's in other continents they have the same issue. So Adwa, your perspective.
It's important and very imperative that we have one African voice when it comes to IP matters. We can still deal with the two IP protocols existing with ARIPO and then the OAPI, but we need to harmonize and coordinate all the legal activities that have to do with IP in Africa. We would obviously have to train people to understand the different regional nuances in enforcing IP laws, but it is doable, and that is something that we can grow to get involved in and to enforce as well and implement.
Okay, thank you. I would like at this time not to be the one dominating the conversation, although I have my little questions here anyway. I would like to move over to Cape Town and ask if in the room there are questions, because I know that there are microphones around. So are there questions direct from the audience? Because it's all about you. It's not about me. It's about you. So any questions? I want my brave audience, live audience, to ask a question. No? No? No, I have a brave audience. For example, I can see a gentleman in a tan jacket right on the front row. He's dying to ask a question. No? I may be somewhere else, but I can see everything you're doing. So no questions from the audience as yet. No? Okay, we need okay, so let's go back to the idea of enforcement. Now, what I have as, again, I'm not an expert. What I am is the other side, the entrepreneur, the person who takes their business to and who invests in Africa. So at the moment, we understand that even when there are laws in place, enforcing it is the most difficult thing there is. So what strides have we taken in Africa to make sure that when the governments do have laws in place, that enforcement is doable, is viable, and enough time and enough education and enough know-how? As for example, there was a masterclass this morning. That's why I was very interested in having questions from the floor on the idea of enforcement. How much is time and the investment is dedicated to enforcement? And let's start with Adwa. Okay. Yeah, I can hear you.
Sorry. All right. So I must say that enforcement in Ghana is mostly on counterfeit goods.
Okay. Mm-hmm.
We do have government agencies raiding the markets and seizing counterfeit goods. We have government agencies at the ports inspecting goods imported and seizing them. And that is how far we go in enforcing counterfeit laws. Regarding trademark and patents, we have enforcement through the Registrar General's Department. If there are any disputes regarding the rights of patents or trademarks, these are handled by the courts. We have precedents where the courts have decided on issues pertaining trademarks and patents and disputes regarding these rights. When it comes to foreign investors, we always encourage that the investor seeks advice from a legal counsel on the IP rights, the trademark rights, the patent rights before an agreement is signed or a company is incorporated or its business or subsidiaries is incorporated in Ghana. We recognize the Madrid Protocol registrations and we enforce that to be used to set up a company in Ghana. We are making strides in terms of awareness to the small entrepreneurs, the tech-savvy young men and women coming up, but that hasn't been very effective because their awareness is probably once every other year. So we're working with the Attorney General's Department, which is under the Ministry of Justice, and the Copyright Office under the Registrar General's Department to enforce and create more awareness. Us as the IPA, we can go only as far as assisting foreign investors in registering technology transfer agreements. But when it comes to the overarching Copyright Office and Registrar General's Department, their awareness has to come from them, and we encourage them to drive it more often.
Agnes, how is enforcement in Kenya? Now, I must say that Kenya has been leading the way a lot in this area. And so I just want to say that I am aware of that. But how is enforcement?
Thank you, Linda. For the enforcement, we continue to enforce the anti-counterfeit laws. And one way that we have been able to succeed in this is through collaboration with other institutions, other government agencies. Sorry, I'm getting some echo. Sorry about that.
That's okay, these things happen.
Yeah, so we've had a lot of collaborations with the various both public and private institutions in our country, and I think that has given us a very good mileage where counterfeiting is concerned, because what we have realized is that most of the counterfeits also come in other forms of illicit, either they're substandard. They are the goods that are evading taxes as they come in, and therefore we work together a lot. We are not yet there, but yes, we are working together. We are also working together with the private sector, and I just want to acknowledge the contributions of Kenya Association of Manufacturers. Of course, even the local companies, the local IPR owners are also affected by counterfeiting. So what we have done with CAM is that they really support even when it comes to issues of awareness. I would want to maybe just highlight a manual that they helped the Anti-Counterfeit Authority in collaboration with other institutions to come up with an enforcement manual and later a practitioner's guide. This is a quick reference point for the various officers when they are out there. The other aspect of enforcement that maybe I would want to mention is, like I said earlier, about the strengthening of our laws. Again, in strengthening of this, we have a provision for compounding by the executive director of the Anti-Counterfeit Authority, which helps us to enhance the alternate dispute resolutions in relation to the IP. And of course, on the other hand, if a case has to go through prosecutions, then we will have seized the goods. There is a time for due investigations, due reaching out to the IPR owners, to the suspected counterfeiter. And once the cases go to court, or even if it is through the alternate dispute resolution, then there is provision for disposal of the counterfeit goods once they have determined to be so. And I want to maybe just reiterate that this one has been quite a deterrent towards counterfeiting. In relation to other types of IP, like copyrights, we have the Kenya Copyright Board. They are the ones that deal with that. They have their laws. So there are also other laws that govern issues of intellectual property rights. I'm not saying we have no challenges. We have quite a number of challenges. But yes, I think as far as enforcement is concerned, we are making some good strides. Thank you, Linda.
Okay. And let's go to the stage. Okay, back to Vanessa, who is all alone on stage, but not lonely, because you have a room full of experts who are refusing to ask questions and join the debate. I'm taking a photograph so that I know who is in the room and chase them afterwards. So over to you. Enforcement, a tricky issue here.
Well, I've got a whole room of enforcers, so I have
Exactly.
to,
That's why I
tread
was
lightly.
That's why I was being provocative, but they didn't go for it.
So one of my passions, and Amanda, who I've worked a lot with from CIPC enforcement perspective, is building capacity and education. We cannot do enough of it. Yes, I know if we look at it, we're hosting this session, we're dealing with the education. We have to raise the confidence, and we are raising the confidence of the enforcers, so to speak. We need number one, the substantive training. If we look at WIPO with the enforcement, and that was specifically dealt with the training of enforcement officials and law enforcement, that is imperative. Number two, we need to work on a basis where how can we actually ensure that this translates into actions in the marketplace. So it is one thing having a session. What works very well and has worked in the past is where we do practical scenarios. What is happening a lot in South Africa and a lot of the other African countries is the joint operations, where we're seeing hands-on training, which is excellent, where you've got different organizations involved in operations from a customs and law enforcement, police perspective, and working on the training. So dealing with in-the-room training, which is always nice, and we get to meet and build relationships. The second one is being out in the field, doing that. Interpol have got a lot of courses available, definitely driving the training and expertise, but we need to do more. And we have to look at online. How are we going to deal with online enforcement, where a large majority of law enforcement officials in Africa don't even have a computer? These are the issues that we have to have a look at. The initiatives such as the app, AJS, which assists and support, those type of technologies can definitely take the enforcement to another level in Africa. On a final note is looking at the prosecutors. We need to have those cases that go through courts. So the judicial training that is taking place in Nigeria, looking at judges training, for example. In South Africa, one of the basis and approach is drive as many of those cases through our courts. We don't have specialized courts, so the only thing we can do is ensure that we've got training of the prosecutors who have the confidence when a docket lands on their desks that they say, we've got this and we've got the support, not only of law enforcement who've brought the case, CIPC, for example, who are doing the training, but also the brand holders who can drive and support the prosecution of these criminals.
Now, before I open it again for questions, let me just be a little bit naughty, Vanessa, while I've got you with the microphone in your hand. And that's it. Now, we invited OAPI to be part of this conversation, and they were unavailable and did not send anybody. But do you think that this division of tradition of former regimes, some based on UK law, etc., and some based on French law, actually contributes more to the division than to the unity? And could this also be something that we could address in future? I'm sorry I'm being horrible to you, but I'm not. It's just that it's a question and it's an issue that is sort of here.
And it's, I mean, we're dealing with a whole lot of factors that really relate in the fact that we have got different laws in different countries. How do we approach it? One of the focuses is actually looking at it from a regional perspective. Yes, it's great to have a fundamental law and position in Africa, but we've got to understand from cultural differences, religious differences. We will always have a matter where there are going to be conflicts when we're dealing with culture. Looking at, for example, liquor and how countries differ in the approach. So how do we bring it all together? There are some things that we cannot. And having, for example, ORP, which primarily are Francophone, etc. I mean, it does at least bring a unity where there wasn't any at all. So yeah, is it the answer? Probably not. It's great. I mean, if we all stand together and sing Kumbaya, that is how we want to be. Is it practical? Not necessarily. But if we approach it from a regional perspective, we at least know that the issues that are being faced in East Africa, where goods are coming in and where they're proceeding, or what the market is dictating with cross-border trade, these can be dealt with together on a regional basis.
Okay, thank you. And I was a bit naughty there.
Doesn't necessarily go around too much around the question.
Now, before I come back to you, I'm going to pass the microphone to Amanda, who is in the room. But first, I want to say that I will come back to you and ask you as a last question before we go off for our comfort break, to think if you could change something now in the next few days, what would be the first thing that you would either implement or change that would move the issue of IP forward? But first, I'm going to pass the microphone to Amanda. Amanda, you're in the room.
Yes, thank you very much, Tess. You were wanting the room to become alive so I can get them to do a Mexican wave for us.
Oh, that would be nice. That would be nice.
But the reason we are here today and we're hosting this hybrid conference is because of our passion for enforcement.
Yes.
Not only as a country, but as a group of enforcement people. So the enforcement topic would be something that we will all stand up for. And the most important for us is training and capacity building. So part of what we are doing this morning, while you were preparing for our good global conference, was teaching on enforcement of IP rights. So for South Africa, I could definitely say that this is a very important topic. We've come a long way, and we are still doing a lot to move forward, and we definitely want to collaborate not only nationally, but also globally and into Africa. So thank you, Tess.
Thank you. Thank you, Amanda. I really wanted to connect the topic to the room, so thank you very much. So I'm going to do a round and perhaps be a little bit provocative. What would you do or change immediately? And I'll start with Agnes.
What would I do immediately? I think over the 10 years that the Anti-Counterfeit Authority has existed, one of the main hindrances is the level of awareness in the country about intellectual property. And therefore, I think if there was anything I would do is to create, to put in measures and put in the resources, which I'm not saying are not there, but resources to be able to reach all the populations at whatever age, inculcation at the school age, right from very small into the tertiary colleges. And of course, we also have so many others out there. These are our prospective business owners, and they are the ones that sometimes will get into counterfeiting without knowing. And therefore, yes, I would want to raise the level of awareness to the maximum possible. Thank you. And
Great.
If possible, make it the preventive measure as opposed to enforcement. Thank you.
Okay. Maureen, my dear.
Thank you very much. But before I come to the question, I'd like to address about ARIPO and OAPI, our sister society organization. And ARIPO and OAPI are currently, we started some years back, working through the Joint Commission in terms of harmonization of the intellectual property laws. So Perfect. It's not that we are not on it, but it's still in progress, and we are making strides on that. And about the trademark, if somebody files a trademark within ARIPO, it takes 12 months because we have 9 months for examination, and then we have the 3 months in case of any opposition. And as a two-tier organization whereby we work with the intellectual property officers in our member states, so we need their response back towards the applications that have been filed using the regional route. And on that, in terms of what has been dedicated to the enforcement and what can be done, we see that even our member states are always conducting anti-piracy raids, putting in place inspection units, monitoring units. For example, also in Ghana, there is the copyright monitoring unit. In Malawi, they also have, they always undertake the enforcement, and they have introduced an arts production marketing cooperative. And this is to increase access of the Malawian creativity for the ones who cannot go and produce, they don't have the money and all that. So using this through this cooperative, then they can be able to enhance the Malawian arts. Another thing is, which maybe we can also borrow a leaf, when you look at the OECD reports, there is about the digital advancement of digital technology. There is, especially on the e-commerce, that the verification of whoever is selling and whoever wants to buy. So the buyer can at least click a certain icon, and then information is sent to the either the IP office or the government database, so that they can verify whoever, whether it's a genuine website, whether it's a genuine seller. And this can be one of the things which we can take up, because we have the brains as Africans in terms of coming up with such kind of creativity and innovation. Therefore, what we need to do, I look at strengthening the already existing synergies, cooperation, and continuous awareness creation. We need to create our own Africa, the story of Africa that respects intellectual property and the balanced IP ecosystem in Africa. Thank you very much.
Maureen, my sincere and profound apologies, because I have just realized that I did not go to you because I received some questions and it distracted me. I apologize and thank you for coming back. That was not intentional, as you must have imagined. Okay, so while we are with you, please do tell me what action you would take immediately then to continue as a closing comment. Maureen.
As a regional organization, we are committed in terms of our technical expertise and also engagement at the high level meetings in terms of ensuring that the IP landscape is respected and we create and co-create value. And just to inform the meeting that our Director General will be joining another meeting this Friday, which will be held at Johannesburg, in terms of all these initiatives for Africa, that we are there, we are committed to cooperate. And having said that, we should advocate transparency and participatory process, because through having this participatory process with national institutions and the regional organizations in Africa, the consultations will be enriched, and then we can have what we all want. An Africa that all the SMEs are able to go and register and protect their intellectual property. Enforcement is undertaken and funds are given so as to ensure that the enforcement is done, and also strengthening the existing penalty provisions, because there may be a leeway in terms of the ones who have been the culprits of IP infringements. They may see that, okay, if at all I engage myself in counterfeit and pirated products, I'm just going to pay very minimal. So we need to have stringent penalties, and if possible, even confiscation of the proceeds of the crime, so that they don't have any other leeway, any other outlet in terms of going back to the same business. We need to have deterrent measures and continuous awareness creation will make a difference. Thank you very much.
Thank you, Maureen. And Awa, what about you, Adoa?
Yes.
What would you change?
I need to shout it out loud. That is what that is the change. Drive awareness through our government agencies. It's very important in that people understand their intellectual property rights. A lot of innovators and creators are unaware of their intellectual property rights, and it's sad to see their works being copied, if I may put it that way, by other third parties and them not being able to protect their rights. Their awareness is imperative in this process. Training and capacity building of intellectual property professionals is key. Us lawyers, our colleagues, and all the other government agencies need a lot of training, a lot of capacity building. Once this is instilled in us, the understanding of how to share intellectual property rights is advocated through the public awareness campaigns that are organized or would be organized. This would help grow the IP ecosystem in Ghana. And that is exactly what I would do to draw awareness to IP rights. Thank you.
Very well put. Thank you. And over to you on the stage, my dear Vanessa. And thank you. And you're having the last word, really.
Well, it's sometimes good to have the last word because I can just add on all the good advice. At least I don't have one switch because I'm sitting amongst members where we've all got a switch that we can switch on. But from our side, if we could change consumer mindsets from a point of view where, firstly, there is that respect for IP and also the enforcement of the IP rights. Number one, if there was no demand for counterfeit goods or infringements, there wouldn't be a market. And I'd have to find another job, which is fine. I would definitely deal in another area. That's not going to go away, but having support where we can actually look at the consumer and their role, and not necessarily leaving it to just law enforcement or government to deal with the issue of IP right protection and also infringement. Having a continent of consumers who are prepared to put up their hands or identify where goods are out there, that is going to support the whole enforcement effort. So awareness, I definitely agree with that, the capacity building, but changing the mindset of the consumer and the respect for IP.
Thank you so much. And I thank all of the ladies. It was wonderful to have a debate with intellectual women, wonderful. And I thank you for your availability and for your frankness and for your directness. Thank you for your time, for joining us today. All our participants as well. Please stay with us. We're going to have a little break, a little comfort break, but come back at 15:30 your time, because I'm on a different time, and for Rights Over Good, which promises to be very, very interesting. And let's have some controversial questions as well. And can the room start preparing their questions right now, the live room? I will be watching you. So have a great afternoon. Thank you, ladies. Thank you for your time, and see you at 15:30.
Thank you.
Thank you.
Thank you.
So good afternoon, everyone. Thank you for coming back. I know that coffee is always very tempting. I can now see everyone in the room looking at their mobile phones. You are being watched. You are being watched. You're always being watched. So thank you for coming back and joining us. And this promises to be a very interesting conversation. We are going now into it's more of a fireside chat rather than a panel, but with two very, very knowledgeable people. So it should prove to be very interesting. So this session is called Rights Over Good. And this panel, of course, will have with us the presence of Mr. John McKnight and Mr. Chris Job, and which is perfectly balanced because we have Chris on the stage in Cape Town and we have John online. So I'm going to introduce you our very knowledgeable gentleman. So John McKnight is a patent attorney who has practiced in both South Africa and the United Kingdom for over 25 years. He's also experienced in commercial transactions involving IP, including issues such as confidentiality, joint development, supply, licensing, and technology transfer. John is a fellow of the South African Institute of Intellectual Property Law. He's also a fellow of the Chartered Institute of Patent Agents, CIPA, and he's a member of the Law Society of England and Wales and of the Institute of Professional Representatives before the European Patent Office. So we have absolutely high standards expected of you, John. Thank you for joining us. And then, of course, we have Chris. Chris Job is a practicing patent attorney with over 45 years of experience in IP litigation in South Africa and other African countries, okay, no borders, with an emphasis of a trademark and copyright infringement. He's a past president of the South African Institute of Intellectual Property Law. He's also an ex-partner and chairman of Adams and Adams, at which he continues to consult. And between 2017 and 2020, he was appointed the honorary professor in the Center for IP Law at the University of Pretoria, where he still lectures today. He's my colleague at Pretoria. I am so honored. So what I'm going to do is, because this panel is really focused on in-depth analysis of how innovation and IP rights are intertwined and the key issues at play, and also should answer the question on how should extraordinary circumstances like pandemics justify the suspension of IP rights as part of extraordinary measures. And I would like to pass the floor to John, who is online, to start the conversation going. And I'm kind of going to let you gentlemen go and have your fireside chat. Two great minds should have a lot to teach us. So I'm going to sit back and only join you when I have audience questions. So, John, the floor.
I just would like to intervene and say, John and I have long discussions about how we will conduct this, and I was going to be the sacrificial lamb to lead in.
Oh, I'm sorry.
With your permission and with John's continued agreement, I'd like to suggest that I do that.
I'm so glad when my speakers become greater than me. Absolutely. So please, Chris, take over. Go.
I'm simply trying to get this over with, if I might be quite honest with you. First of all, thank you very much to the World Intellectual Property Organization and to the CIPC for inviting me, for the honor of being able to present a subject to you, which in fact is not so much the big debate, which we heard a little earlier today, or this afternoon, but in fact it's the hot debate. And it seems to be getting a lot hotter recently, and it needs to be addressed. It's critical that it be done. How exactly is something that we can try and discuss, and John will no doubt have ideas about this. There is an essential paradox that confronts us in this regarding patents for pharmaceutical products. The entire theme of the conference and of the workshop that we've been listening to and working through has been the protection of intellectual property rights. Every speaker has spoken up to say it's imperative that we protect intellectual property rights. And now it comes to a situation where it's a little uncomfortable to exercise the intellectual property right. Then suddenly we shouldn't enforce the intellectual property right, or not entirely. Now, we listened earlier this afternoon to a very impassioned plea and delivery from Secretary General Mene of the African Continental Free Trade Area. Very appropriate and very heartfelt, and undoubtedly what he had to say would have struck a chord with each and every one of you. Who anywhere would not believe in the absolute pinnacle right in the context of human rights as to the right to health and health care? I mean, who could possibly doubt this? It has to be. There's nobody in this room who would disagree with that plea and that proposition in any way. It's essential. But then one has intellectual property rights. And we all know, I think, the social contract, if you like, and philosophy behind awarding exclusive rights to innovators, and particularly in this field, to the pharmaceutical companies, the big multinationals and others who do spend a fortune at great risk trying to invent and create medicines in all different contexts. And of course, we're talking here primarily now about COVID-19 and all the difficulties of that. So without those inventions, humanity would suffer terribly. And so this is the paradox. And of course, the solution, at least in theory, is to try and balance these rights in some appropriate way. President Ramaphosa last week appeared on behalf of the African Union members in, I believe, probably the same meeting that Secretary General Mene referred to this morning at the WTO. And I'm just reading some Eyewitness News headlines here. Ramaphosa discusses vaccine inequality with European and African Union members. And in the article, it says that African leaders are still pleading those in the medical industry to waive their vaccine IP rights, making their formulas accessible to the public. Speaking to the SABC, President Ramaphosa criticized Europe for seemingly doing more to protect IP rights holders instead of the greater good. And then I quote, he said, "We have made some progress. It is there yet in terms of unlocking the TRIPS waiver. We have raised the issues very sharply, and we have actually said it is Europe standing in the way of a full agreement on a TRIPS waiver, about which more later, because they have been trying to protect those with intellectual properties." So there is the plea appropriate to release, if you like, and make available vaccines, either free or at affordable prices, and who would possibly disagree with that? On top of that, I'm looking at the Pfizer full year 2021 results, which was published last week, I think. And it is remarkable that the overall results, the revenues, the income derived by Pfizer in 2020 for that financial year, $41 billion US, and in the most recent financial year, $81 billion US. It's a 95% increase in revenue in 1 year. And if you go deeper into these results, you will see that that has been driven by the COVID-19 vaccine. Vaccines in the full year 2020 derived a revenue or enabled a revenue of $6.5 billion US for Pfizer, and in the current financial year, $42 billion. an increase from 6 billion to 42 billion on the back of the COVID. Now, these numbers, of course, are over our heads. They are massive, and they seem, at least on the surface, to smack of excessive exploitation of the patent right. And huge profits can indicate this. There's no doubt about it. But what my initial task here, and what John and I seek to do, I wish to sketch the international context relating to health rights and intellectual property, particularly patent rights, how it translates specifically into the South African context, but for South Africa, you could read many of the other African countries. And then we will look at limitations that do in fact exist in relation to the exercise of patent rights. So the legal framework, there's a very specific international context and framework for each category of rights. And I want to start with health, because let's start there, because that is the great concern. Public health is paramount. In 1966, there was an international convention held on economic, social, and cultural rights. And this was a convention which most countries now have acceded to and are bound by. And bottom line of the International Convention on these rights was that everyone in every member country has the right to the highest standard of both mental and physical health. And so countries have bound themselves to ensure this. It was recognized at the time that you can't flick a switch and overnight suddenly everybody has wonderful access to the best medicines and healthcare. It was recognized that a progressive achievement would be necessary, but certain core minimum standards were put in place. Now, these rights, it's all very well. In South Africa and many other countries, if our country accedes to a convention or a treaty, that doesn't give it the force of law in South Africa. So we sign up to a convention, and yeah, that's great, but there are no teeth to it, and there's no driver to make it actually happen in South Africa. And so this convention can be introduced into and made effective in countries either through direct legislative provisions or as an influence in the interpretation of legislative provisions and statutes in other countries. South Africa, fortunately, has adopted the direct system, and it has specifically enacted in our Constitution, in the Bill of Rights in the Constitution, Section 27 guarantees the public right to health and health care. So it's a matter of law in South Africa. It's a matter of constitutional law that this has to be provided. So park all of that and think for a minute of the positive and the good intentions and the practical good effect of that law. Now let's look at the intellectual property context. The intellectual property rights, internationally speaking, are and have been primarily driven and defined, first of all, in the Paris Convention. And certainly for many decades, the Paris Convention, and particularly Article 5A2, and by the way, the Paris Convention is administered and driven by the World Intellectual Property Organization. Article 5A2 of the Paris Convention gives members of the convention, and most countries on earth, including South Africa and most African countries, are members of the Paris Convention. And they've been given the right to introduce compulsory license provisions where a patentee in a country might be abusing the right in some way, and a local manufacturer or party may apply. There's a process and a procedure. You go to the Commission of Patents, it's a high court in effect, for a compulsory license to manufacture that particular article or pharmaceutical or any product. This is not specific to pharmaceuticals. I'll come back to this question of abuse, or maybe John will deal with that a little bit. Post-Paris, after the Paris Convention, it was felt that there was some lack of drive and focus by the countries in the world to give effect to some of these provisions. And that's where the World Trade Organization got behind and produced, and members joined, the TRIPS agreement. So when we hear about President Ramaphosa talking about unlock the TRIPS waiver, I mean, anybody reading that, it doesn't make any sense. TRIPS is an agreement. It's the trade-related aspects of intellectual property law, and it is part of the GATT round under the World Trade Organization. Now, again, most countries in the world, including South Africa and African countries, are members of TRIPS. Now, TRIPS steps in to this question, many questions, but one of the issues for our purposes that it steps into is this question of abuse of patent rights. And for purpose of this discussion, let's just keep thinking pharmaceutical patent rights. And it has a lot of sensible provisions, which exist and are still in force. So it will enable, subject to certain conditions and limitations, use of a patent. In other words, the manufacture of a pharmaceutical without the authorization of the owner, the patentee, as we call it, the person who owns the patent. This is Article 31, by the way, for those who are interested. That's A. Sub B says that if you want to do this, you have to request it first from the patentee. You have to propose a license on certain reasonable terms. And if refused, then you can go forward, subject to the further provisions of this article, with applying for a compulsory license. And it also provides, and this is very important to note, that this pre-request, going to the patentee first and saying, please, can we have a license, can be waived in two situations. If there is a national emergency or extreme urgency. Now, if the COVID-19 pandemic hasn't given rise to a national emergency and an extreme urgency in every African and global country on earth, whatever could be seen to do so. The article continues that in granting such a license or requesting, there has to be a limitation on the scope of the right, the duration of the right to manufacture. The person granted the compulsory license cannot manufacture any quantities and export it all over the world. There's got to be limitations as to where this product may be sold and used. The license will be non-exclusive, so they don't get a monopoly and then can in turn themselves enforce abuse or abuse the right. He can't assign or cede or transfer the right to anybody else. And then, importantly, Article 31F said that such manufacture had to be primarily for the domestic market of the country in which that license, compulsory license, is granted. So it's only predominantly for internal use within the country. The right has to be subject to judicial review and some other provisions. And adequate remuneration, of course. The patentee has to be paid, but it has to be adequate, and that will have to be determined by a court or an authority charged with these things. Now, that's all very well and good. So now you can, in the case of national emergency, if there is a serious situation, you can now get a license, compulsory license, to manufacture primarily for your local market. Problem, particularly in the African and other contexts, least developed countries very often, and developing countries, very often don't have the ability to manufacture pharmaceuticals. It's highly technical and very resource intense. So here's a country which is desperate for a compulsory license, but it cannot make the product. It doesn't have the ability for whatever reason. And arising out of this difficulty, in 2001 and then leading into 2003, there was a meeting under WTO it's called the Doha Convention, or Doha a declaration that came out of it, where this problem was specifically addressed. And the declaration under Doha agreed that limitation under Article 31F, where you could only manufacture product for the local consumption, was waived for members who would export, who could manufacture and would export to countries, eligible members or countries, which couldn't because they didn't have the ability. So suddenly, for example, South Africa could, under these provisions, if a South African manufacturer, like Aspen, for example, were to manufacture the product here, in terms of this and subject to going through the procedures under this article, export and provide the product to other countries where without the ability. Now this waiver, and this is really the TRIPS waiver that has been spoken of, was then enacted and became part of the TRIPS agreement. And I think it was post this would have been probably around 2005. TRIPS was amended and Article 6 bis was introduced, and Article 6 bis allowed and now put into formal situation this waiver right. Now, just to conclude this part of the discussion, this right, the patent right now, we've discussed the right to healthcare in South Africa under Section 27 of our Constitution. Similarly, Section 25 of our Constitution protects property rights as part of the Bill of Rights. So property rights, and by the way, the courts have interpreted that to include intellectual property rights, so that will include patent rights in pharmaceuticals, is given equal status under the South African Constitution. And so now you have a situation. Section 36 of our Constitution provides that any law may be limited and restricted if it is a law of general application, like the Patents Act, and as would be appropriate in a fair and reasonable, in an open democratic society. So our Constitution then itself recognizes that the intellectual property right under Section 25 can be limited. And that is where we now turn, and we made to the South African situation and the provisions that exist here to give effect to all of those fine words and fine concepts. And I think it's John's turn.
Well, thank you, Chris. Trust everybody can hear me. If you can't hear me, I'm sure they will hear you soon enough. So, Chris, thank you for that introduction. And I will now explore the framework that Chris established with particular reference to the South African situation. And so doing, I will stand on the shoulders of giants. So I'd like to begin by just, Chris touched on it early on, the philosophy behind the Patents Act. And this is embodied in TRIPS. And so it appears in all the patent facts. Each country around the world has its own Patents Act. They're largely harmonized, but they all subscribe to these central tenets. And that is, patent legislation is unique in the sense that whereas we think of most acts in a country, it's very prescriptive. Thou shalt not do this, thou shalt do that. And if you fail to do any of those things, then you can expect the following punitive provisions to be visited on you. So it's very prescriptive and authoritative. The Patents Act turns that on its head. The Patents Act is incentive. It says basically, if you solve a problem that afflicts society, and you teach us that solution, as long as your solution is new in the sense that it has never been disclosed previously in the history of mankind, and inventive in that it has a technical advantage, you will be rewarded with a 20-year right to stop others from practicing that solution, the invention that you've taught us, right? And in so doing, you get to enjoy the whole profit and advantage accruing by reason of that invention. So it is a quid pro quo, it's a deal. And the government of each country says, if you solve a problem, we are very grateful because we couldn't solve it ourselves. And in return, as a reward, as a thank you, you get this 20-year monopoly to prevent others from practicing the invention. So it's not a stick, it's a carrot, because it says, if you do this, then you get that reward. And this is the central tenet. This is the inherent philosophy in patents. So I really just wanted to establish that first, because it makes patent law very interesting, and it makes patent law distinct from other areas of legislation. So having established that as the parameters, Chris mentioned that these rights, and they are property, just like houses and cars are property, they have their limitations. And the first thing I want to talk about is expropriation, because Investopedia defines expropriation as the act of a government claiming privately owned property against the wishes of the owners, ostensibly to be used for the benefit of the overall public. Now, when we think of expropriation, we might have a large property, and it is just announced that the government is now taking a portion of your property because they wish to build a highway or something like that. But of course, given that patents are property, not unlike houses and cars, it's only to be expected that a government will reserve the right for itself to expropriate these patents, these inventions, should the need arise. And South Africa is absolutely no different in this regard. The Patents Act, and our Patents Act is number 57 of 1978, so it's been around a while, it's stood the test of time, provides plenty of opportunity for government acquisition of these patents, of these inventions, and yet strangely, even considering South Africa's, the grave challenges that face us, COVID, HIV, tuberculosis, especially in these pharmaceutical areas, these provisions have never been used. So let's explore why and what the existing avenues for expropriation, for want of a better word, are. And I don't want to go into chapter or verse of the Act, but having said that, that's exactly what I'm going to do. Okay, so we're going to kick off with Section 4, which says state use, and it says, Section 4 of the South African Patents Act says that a patent shall in all respects have the same effect against the state as it has against a person. Okay, I can get behind that, but provided that a Minister of State may use an invention for public purposes on such conditions as may be agreed with the patentee. Okay, that's interesting. The most interesting thing about Section 4 is that it relates only to use. So if we delve into the absolute heart of the Patents Act is Section 45. And that's the one which sets out what I was telling you earlier about the quid pro quo, about if you provide the solution, then you get the monopoly. And what it actually says is the effect of a patent shall be to grant to the patentee in the Republic, subject to the provisions of this Act, of course, for the duration of the patent, the right to exclude other persons from, and then it lists the acts, making, using, exercising, disposing of, offering to dispose of, or importing the invention, so that he or she shall have and enjoy the whole profit and advantage accruing by reason of the invention. Okay, so there are a number of acts, 6, I think, by my count, 5, that you can exclude others from doing. But Section 4 only says use. So the government can't make, it can't exercise, it can't dispose of, it can't offer to dispose of, or import the invention under Section 4. It just gets to use it. Okay, not brilliant, but you can see how it would be useful under certain circumstances, right? Particularly in this instance of COVID vaccines. But the Act doesn't stop there. We go a little bit further, Section 78. They call it state acquisition. And this really goes a whole lot because it just says, simple, the minister may, on behalf of the state, acquire on such terms and conditions as may be agreed upon any invention or patent. Okay, end of story. Takes the whole thing, takes ownership of it, and all of those acts that I mentioned previously, making, using, exercising, disposing of, whatever, they all then belong to the government. Now, the only requirement is that on such terms and conditions as may be agreed upon. And you will recall that existed in Section 4 as well. So that's interesting because both Sections 4 and Section 78 require a negotiated acquisition, negotiated access, as is now contemplated by the legislation, rather than unilateral expropriation or expropriation with no recompense. Now, what's interesting about that is that South African legislation does not provide for the waiving of a negotiated acquisition in the case of a national emergency or other circumstances of extreme urgency. Even though the TRIPS per se and the Doha Declaration specifically allow for the waiver of that. So in terms of the Doha Declaration, it says, these are the words: each member has the right to determine what constitutes a national emergency or other circumstances of extreme urgency, it being understood that public health crises, including those relating to HIV, AIDS, tuberculosis, malaria, and other epidemics, can represent a national emergency or other circumstance of extreme urgency. You really can't get it more clear than that. The Doha Declaration says AIDS in and of itself is a national emergency, and that would give the government leeway just to walk in and expropriate all these patents and use them for the treatment of AIDS. And yet we choose not to do that. The South African government chooses not to do that. Okay, so we're just going to park that there for the moment because I find those two aspects very interesting. But Chris also touched on compulsory licenses, which is a big thing in TRIPS, and it's a big aspect of the South African patent law. It's a major check and balance built into the legislation. And that is compulsory licenses, basically section 56, for those who are interested. Any interested person who can show that the rights in a patent are being abused may apply to the commissioner in the prescribed manner for a compulsory license under the patent. So what's interesting about this? Any person. So it's not just the government. Only the government can use section 4 and section 78, but any person can apply for a compulsory license, okay? So, and we've got quite a good body of compulsory licenses in South Africa. And the courts have come to examine this and entertain applications for compulsory licenses previously, but to date, none have ever been granted. Okay, so this would be despite the HIV/AIDS related public crisis and the perennial arguments that medicines are unaffordable due to the anti-competitive patent laws. No compulsory license has ever been granted under a South African patent, despite several applications of this. And now we have to look at this. We've got these provisions, we've got these TRIPS flexibilities, and yet they have never been levered in the South African context. And why is that? So we can take some learnings, and I think Chris will talk on this a little bit later, and that is the treatment action campaign and the HIV crisis in the early 2000s in South Africa. It was a very instructive period in law. So civil society has been very successful in bringing about pricing changes and increased distribution of medicines through the use of an active citizenry, skillful interpretation of the Constitution, as Chris mentioned, and the threat of applying one or more of the provisions as laid out before. So, and I'm particularly referring to the treatment action campaign of the early 2000s, when South Africa was in the grip of an HIV denialist executive. So what happened there? It was largely settled, but the point being that because these provisions existed in the legislature, it provided a crucible, an arena in which the parties came together and eventually reached an agreement, because they knew what would happen if they didn't. They had all these provisions that they could fall back on. And you know, the drug manufacturers realized that they could be facing state acquisition. The parties were realizing that, you know, they'd have to go this route, et cetera, et cetera. So by having these allowances built into the act, it allowed the parties to come together and reach an agreement. So that, I think, in itself is very, very instructive. So whilst it's clear that the South African government currently has a significant arsenal at its disposal to both use and acquire patents from the private sector, and they have the leeway to introduce even further reaching legislation, for example, by waiving the requirement to reach an agreement with the patentee, they choose not to so far, okay? And believe me, I'm the last one to speculate as to the rationale behind government policy. But it does seem that, like, at least in the SA context, history bears out that the needs of the community can be addressed within the existing structures available. And until that begins to fail, there's really no need to revisit the legislation. Having said that, there is a white paper which is looking at this in itself. So I'm the first to say that this needs iteration, but presently, given the leeways that are available, that they're not being taken up. So I'm now going to fly my colors, and I invite response from the audience. But when we look at the continent globally, the asymmetric vaccination rollout in Africa, in developing countries compared to developed countries, is both indefensible and incontrovertible. And there are many reasons for this, but I suggest that patent law is not one of them, okay? If we talk about IP waiver, we are really, I don't believe that sits at the core why you have this great disparity in vaccination between Africa and Europe and the West, okay? And I just want to touch on a couple of points as to why I think an IP waiver will not be effective in addressing this discrepancy, okay? So first of all, waiving IP rights, I don't believe will speed up vaccine manufacture. The delays are caused by shortage of raw materials, insufficient production capacity, highly complex manufacturing processes. These are factual problems which afflict the continent and many countries, and waiving IP won't address these factual issues, okay? IP rights are useful in the sense that they underpin collaborations and contracts, working together, joint ventures, pooling of resources. If we both have our areas of monopoly, we come together, we can be synergistic in the approach. So waiving IP takes that off the table, and so collaborations will wither on the vine, okay? IP waiver does not address the regulatory requirements, the dossiers, the confidential information, the phased clinical trials, et cetera, et cetera. That's an enormous bridge to overcome. Each country has its own regulations, own regulatory framework that has to be compliant with. IP regulation will not affect, waiving IP will not affect that, okay? IP waiver does not address the enormous logistical challenges for rolling out vaccines. I'm talking cold chains, I'm talking about booster shots, I'm talking about the huge administrative burden about recording who's been vaccinated, who hasn't, when's the booster needed, getting the vaccines in an administrable form into remote areas, etc. These are massive logistical challenges. IP waiver doesn't address that at all. Finally, as I've mentioned, and excuse me if I bang this drum, but the TRIPS waiver already includes sufficient flexibilities to prevent the negative effects of intellectual property, as Chris and I have discussed, Chris globally, myself in the South African context. And of course, finally, and most importantly, going back to my original point about the incentivization that underpins the Patents Act, an IP waiver will massively, detrimentally affect the incentive for drug innovation. Chris mentioned the massive, and I would use the words obscene profits that Pfizer and the other vaccine manufacturers are declaring. And they are disagreeable. I think everybody will agree that doesn't sit well. But the fact of the matter is, today's profits fund tomorrow's drugs. So without these profits, we will be in a difficult issue if we face another pandemic. And we will, maybe not in our lifetime, but there will be another pandemic. And there need to be companies footed who have the resources to quickly and radically provide these solutions and roll them out. Look, don't get me wrong, this pandemic, COVID, was the opportunity for big pharma to be the hero, but it's clear that the asymmetric rates of vaccination between developed and developing nations seems to suggest that they've squandered the opportunity, okay? And there are lessons to be learned on both sides. But if I can just tell you what I've already told you, I think that the problems associated behind inequality in access to vaccines are not IP, and in particular are not patent related. So on that basis, I apologize if I'm being controversial. As you might imagine, I'm a big fan of the Patents Act. I am a practicing patent attorney. I believe in it. I believe in its inherent worth to society. And on that basis, I invite comments.
Well, perhaps I could just lead in with a few, John. Heard you loud and clear. What are we talking about, this waiver? Is it a waiver of the right to export to non-manufacturing countries in terms of Article 6 bis now of TRIPS? Or is it a waiver of the rights completely in terms of specific legislation, possibly Section 78 of the Patents Act? And what puzzles me, and what I would really like to know and understand, and it's going to inhibit this discussion, I don't know exactly what went wrong in Europe last week. I don't know. We're not privy to those discussions. What exactly was on the table? Was it a request to, under the Doha arrangement, to allow, say, a South African pharmaceutical company or companies to be granted compulsory licenses so that they may, in terms of that waiver, export to countries which do not have that ability to manufacture? Is that what was on the table, which has to be done subject to terms and conditions? There has to be a negotiated outcome. Or was it some deeper waiver? And I simply don't know. It's not clear from the matter that we've read. We've heard Secretary General Menezes today talking about how the European WTO, I presume, blocked this attempt to waive the unknown right. So I'm not sure what went wrong, but I hear what you say, that even such a waiver wouldn't solve the problem. But it's got to be step one to getting, at least having the legal right to do this. And these all come back, and you've mentioned, it comes back to negotiation. And did the wheels fall off at the WTO last week because they couldn't agree on the price of the royalty to be paid to the patentee? Or was there some other more fundamental difficulty? Because the TRIPS agreement and our Patents Act specifically provide for compulsory license where there is an abuse of rights. And an abuse of rights is in turn defined in various ways, but excessive pricing is one of the provisions of Section 56, and not satisfying the demand of the public. So you've mentioned that no compulsory licenses have been granted. Quite apart from going to Europe to talk and try to negotiate on a broader geographic basis, why has there been no attempt to obtain a compulsory license in South Africa on negotiated terms, in specifically the COVID-19 context, from specifically Pfizer and or Johnson and or one of the others? And I simply don't know. I'm ignorant. We're not privy to that. But abuse of rights is cardinal to this whole, and we are potentially facing an abuse of rights, excessive pricing, massive profits. But there is a remedy. And that's the question.
Thanks, Chris. I agree. I was just reading the news today, and I see that there has been approach to the court under the Freedom of Information to see if we can get some more detail on what deals were struck by the South African government with the vaccine manufacturers. I think there is a non-government organization that has approached the courts. They want some more clarity on this, on the pricing issues, et cetera, et cetera. One thing I would say is, there was also a recent article, I read it in the Sunday Times this week, that there has been an agreement of transfer of technical packages, including the know-how, et cetera, such that manufacturing facilities can be established now in 6 African nations, South Africa, Senegal, and various others, following this technical transfer. But there was concern expressed about who would offtake from these manufacturing facilities. Would it be the governments? Would it be COVAX? Would it be charities, et cetera, et cetera? So obviously, as the accountants will tell us, it's the bottom line. The pricing and who will be buying these vaccines, which are so important, and establish the viability of any manufacturing hubs that may be established across the continent. So I think from my side, that's about it. I would welcome the opportunity to take questions from anybody who might have anything or even criticism. It's all good.
Thank you both. Are there any questions in the room in Cape Town? Everybody's very quiet. I think you've left everybody kind of flummoxed. No questions in Cape Town? The room is quiet. Tess, Amanda, no questions in the room.
We have one.
Oh, we have one. Great.
Okay, thank you. Thank you for the opportunity. I just want to make not a question as such, but I don't understand how this is contributing to my understanding of this workshop, because according to my understanding now is we are talking of Section 25 of the Constitution, Section 27 of the Constitution, and the expropriation of patent rights that is beyond the scope of my understanding other than the legislators. That's my question. That's my understanding.
So would one of you like, John or Rob, would you like to take the conversation?
Chris, shall I begin?
Well,
and then
Chris or John?
I understand the point fully. I understand it, but my understanding of the conference was that this is all about IP in Africa and understanding and progressing. This part of the conference is not, as I understand it, intimately tied to the workshop, which is all the anti-counterfeiting enforcement of rights. Understood that this conference has a broader basis, and it's to promote and evoke debates and differences in the broader context of Africa and IP rights.
Exactly
so it's outside
right.
of strict enforcement. That is my understanding. Not being the author of the topic, I can't say anything more.
That is exactly right, John.
Okay, thank you for the explanation or the elaboration on that. According to my understanding as an individual, this is an opinion, it's not factually related. I think the government, in terms of waiving the patent rights or seeking to get those rights in terms of the COVID, they did very well. If we look at the Qabecha production scheme, where the production of COVID vaccine is in the pipeline, we can see that such amount of production that is directed to Africa is a very huge step forward. And I believe if time allows, we might be talking of something that is very exciting from now on. I thank you.
Could I just add a few aspects to this discussion, Linda, if I may? Yes, we are horrified by the profits made by Pfizer, but we actually have no real understanding of the cost behind it and the risk taken. And I'm not defending them. I have no idea. But I will say that an interesting case, which was touched on very briefly by John, was actually brought in South Africa some years ago by the Treatment Action Campaign, the TAC, against, it would have been against the patentee, the patent holders, GlaxoSmithKline, GSK, which held patents on antiretrovirals for the HIV/AIDS treatment. And what is interesting about this is it was brought under the Competition Act, nothing to do with the Patents Act, abuse of rights there. But Section 8 of the Competition Act has specific provisions where there is, if a dominant firm, if a dominant entity, as GSK and Boehringer Ingelheim in that case, were in that market, they had certainly more than 45% required by Section 7 of the Competition Act, where they abuse their position in the market, in exploitation, then the court can grant a license or limit the right. Now, in that case, it was proven that there was excessive pricing, and there was also a refusal to allow access to an essential facility, which was the patent right in the invention itself. And so understand that the Competition Act actually defines excessive pricing, which will lead presumably to excessive profits. Excessive pricing is defined, and it's very simple. I'm not quoting verbatim, but it looks at the cost of the development against the value of the right against the money, the profit, or the charge for it. And it seeks a balance. And in that case, it wasn't as if GSK was obliged to give a license to manufacture these antiretrovirals free. But the court, in fact, it was the Competition Commission, came and it set a number. It balanced these rights. So there's another avenue which can be followed by anybody. And excessive pricing is at the heart of it, as it is under the compulsory license provisions of the Patents Act. So before we start talking about these massive charges and incomes, we need to have a balance and a balance against what it costs to get there. I'm sure there's huge profit. Whether it's excessive as defined, I can't say sitting here. But let's just bear in mind that coming full circle to the beginning of this debate, if I may, and start to draw this discussion to conclusion, is that we are dealing here, the paradox is two guaranteed rights, both at the global international level in terms of conventions and treaties, and at the South African level and all African countries. These two rights, and the only way forward that I can see is that there be carrying on with the discussion, further negotiation, because you have to strike a balance. And it seems that the European Union and or WTO, they've dug their heels in on maybe the demands were too great, and they've now pulled back in a negotiating stance. But it seems that the meeting of the minds is imperative to move forward with this whole conundrum, which is plaguing humankind. We have to break through these things.
John, over to you.
Well, I think Chris has summed it up very nicely. It's all of these things, and as always, it's a balancing act. To use a benign example, I have the right to swing my arms, but that right ends when my flailing limbs meet your nose. It's a balancing act. I have certain rights, you have certain rights, and we should meet in the middle, such in a sustainable way, in a moderate way that meets both parties' imperatives, and reasonableness must prevail. But I would guard against a waiver of intellectual property, to tinker with the incentive to disregard the rights and the protections which exist for the significant investments that have been made to bring us these vaccines and to bring us the next generation of vaccine. It is remarkably dangerous to undermine those rights. And I think it imperative that they be respected and they lie at the heart of any discussions going forward.
Thank you. Thank you. And Chris, perhaps some closing words from you, because we don't have any questions, so we'll wind down. So your final comments.
I do not oppose that at all. John and I are very much on the same wavelength. He has been very pro-patent, as I am. I believe in the system. It gives incredible, without that incentive to innovate, we wouldn't have COVID vaccines if it wasn't for the system. So may humanity just stop and think about that for a minute. But as I've said repeatedly, it's a matter of balance, excessive pricing and abuse of rights. And quite frankly, if I may leave this with this conference or this discussion with the following question: what is going on? What is going on behind the scenes? What is our government, or on behalf of the AU, our president, what exactly is being requested? What exactly has been refused? But it seems that there's clearly been a failure to come to some reasonable negotiated outcome. And all I can say is, you were asking the previous, you asked the previous panelists, what would you do now? If you had right now, what would you do? I would say a terribly boring thing. A, find out what went on, and B, carry on talking.
Yes.
There's no quick fix.
Perfect words. Thank you. Perfect closing words. John, would you like to say a few last words?
Thank you, Linda, and thank you, Chris. I couldn't agree more. I think in closing, I'd just like to echo your point that if you think rolling out a vaccine is difficult in a landscape filled with patents, try rolling out a vaccine when you don't have any patents. There will be no vaccine to roll out. Thank you.
That it could not be put in any better way. Thank you so much. Thank you for both of you. Thank you so much for your insight and for your forthrightness and straightforward. I love that you were straight to the point, and that is amazing. Thank you very much. You contribute greatly to the debate, and I am sure there will be feedback on this. Thank you both for your time and for your generosity. Thank you, John. Thank you, Chris.
Thank you, Linda.
Now,
thank you very much.
Thank you. Now, tomorrow, we will be back at the same time for our sections, starting at 1:30 for the conference, the training, of course, in the morning. And I cannot overemphasize the gratitude and how happy and honored we are to be partnering with the Companies and Intellectual Property Commission. Thank you so much. Well represented in the room, and we will be back with them tomorrow. Tomorrow it will be very, very interesting again, because tomorrow we're going to talk about Africa in comparison, and we're going to be talking about issues that involve us all, and how can Africa's business and consumers get involved to litigate for competitive IP services, lots of issues. And then after the coffee break, we will focus on the supply chain, and we will address accountability and collective responsibility. So I hope that you join us tomorrow. To all the people in the auditoriums, I hope you join us again tomorrow. We were very honored to have you here today. And thank you to the room in Cape Town. And let's have a lot more questions tomorrow. Thank you all for joining us. See you all tomorrow.
I think all of you are